SJC-11910, Commonwealth versus Barnett.
Mr. Shedd, good morning.
Thank you. My name is Dennis Shedd, and I'm representing Michael Barnett. Jurors find DNA evidence, whether inculpatory or exculpatory, more persuasive than any other kind of evidence. And a strangulation case is one where you're probably most likely to find handler DNA on the murder weapon because it has to be held in both hands with a lot of force for a considerable amount of time. Trial counsel in this case could have presented evidence that Barnett is excluded as a contributor to the DNA on the cords that were used to strangle Christopher Souza, but he didn't. He could have moved to exclude the Commonwealth's DNA results, whether they're deemed inconclusive or non-exclusive, but he didn't. The DNA charts report that the Commonwealth produced in discovery stated that there was insufficient data to include or exclude Barnett from the DNA that was found on the cords. And counsel thought that was good, so he never considered the possibility of retaining his own DNA expert. But the charts that were included in that report should have caused him to investigate the possibility that Barnett should be excluded as a contributor. Those charts showed that he was missing at least 6 alleles that he had that were not present on those cords. In addition, he should have been aware that the interpretation and comparison of DNA profiles is a subjective process, and different examiners can come to different conclusions. So without investigating the reliability of the Commonwealth's DNA evidence, he was in no position to decide how best to defend this case. Now, if he had retained a DNA expert, he would have been able to present evidence that Barnett should have been excluded.
Wouldn't that have just led to a battle of experts? Because, right, the Commonwealth responds that Walsh, who's, I guess, their DNA expert, that the counting the number of alleles missing from the DNA evidence profile is not a method they used to exclude, right? So
That's right.
We would have been basically in an inconclusive state regardless, right? They would have gotten up and said the opposite. So what would it have accomplished given how little use is made of the DNA evidence anyway?
Well, what it would have accomplished is, it's similar to what was accomplished in the Epsom-Millian cases, where the court pointed out that in cases like this, you do want to have a battle of the experts if that's what's involved. But what happened here...
Was that an inconclusive case or a non-exclusion case?
Well, Epsom-Millian were shaken baby cases, actually. Mm-hmm. The other DNA cases are the Cameron and Cowles cases. But in this case, what it would have accomplished is that in the initial affidavit that our expert, Stephen Lakin, filed, he did refer to the number of alleles that were missing, but that's not the sole thing he based his opinion on. And he goes on to point out that the reasons that the Commonwealth gave for arriving at the inconclusive result don't hold up. And they cited 3 possibilities. One was the expert at trial testified the missing alleles, they may have just dropped out because of the low level of DNA. Well, from that, the jurors might have inferred that, in fact, if they'd only had more of a sample, then they would have been able to include Michael Barnett, which provided some corroborative evidence for the Commonwealth's other evidence. The other point is that there's a world of difference between being satisfied with inconclusive evidence, something that basically provides no benefit to either side, and having an opportunity to get evidence that would have excluded Michael Barnett as a contributor. And that's what would have happened here. And as to the affidavit from Sharon Walsh that the Commonwealth submitted, that also shows the biased nature of the Commonwealth's results. She stated in her affidavit that she focuses first on these smaller, more robust alleles. In examining the microphones, she singles out missing alleles at locations D5S818 and VWA as reasons for an exclusion. When it comes to the cords, though, she ignores those 2 alleles and turns to 3 other alleles that are approximately the same size. It just so happens there are none of Michael Barnett's alleles missing on those 3 that she looks at for the cords, but he's missing alleles on both the other locations that she looked at for the microphones. Now, so in this case, if counsel had retained an expert, we would have been able to present evidence that Mr. Barnett should have been excluded as a contributor to DNA on the cords, and he would have been able to show that the Commonwealth's expert, Brian Cunningham, didn't follow the lab's own interpretation guidelines, and he arrived at inconsistent results.
These are cords on a video console of some sort, right?
Excuse me?
These are cords on the video console. The cords the DNA which we're fighting over on the cords are also sort of DNA. The cords are used to connect the video games, right?
Right.
So, I mean, what is it? We're gonna have inconclusive or exclusive DNA on these cords, but the cords are likely to have been touched by lots of people, right? I mean, there are a lot of gamers using these games, right?
Well, this is somebody's personal game. It's not like a video game console at some game center in the center of town or something like that.
I know, but he's got friends over playing it. His brother plays, he plays, this guy plays. The defendant's at the house that night, right?
He is.
And the defendant's found with a video console that appears to be the same video console, right?
He
Lot of
sells a
evidence here.
video console the next day. The one he sold is not definitively tied to the victim, Christopher Souza's console.
Right, it's not definitively tied, but
Right.
Right.
That's right.
Can I go back to the,
If I can,
We all have questions, apparently. Go ahead.
if I can pursue that with regard to, I'm one of the only people in the country who never had a PlayStation. So how consequential is it that the records of Sony have it registered only to Guess's nephew, I guess, or name, and not to Souza?
Well, there certainly are a lot of PlayStations in the world. And the state of the evidence here is that it doesn't exclude the possibility that somebody else came into that apartment after Michael Barnett left and killed Christopher Souza. So that's the point there, is that the records do show that what happened here is that on the second day of trial, the ADA issued a subpoena for records about a PlayStation with a certain ID number. And the records that come back show that it's the PlayStation that Mr. Jesse activated a couple of weeks later, but there's no they don't show that it was the PlayStation that Christopher Souza owned. And the other point on that is that the evidence shows that the PlayStation Christopher Souza owned was working at least 2 days before. The one that Mr. Jesse bought from Mr. Barnett was not working properly, and he threw it out shortly after he got it. And also, there's no evidence that Mr. Barnett ever had the Xbox that was taken from Mr. Souza.
So, but going back to the PlayStation, does that only mean that somebody sent the card to Sony, or must you contact Sony to activate something in order to use the PlayStation?
No, I don't believe you have to send somebody to Sony to activate the PlayStation. All they did is they asked about this PlayStation with a given ID number, and they got records from Sony about what email address had last activated the PlayStation with that ID number, and that's how they got it down to Mr. Jesse.
What does that mean, that it was never activated before?
No, it had, I don't know if it had been, that's all the records show, is that it was activated these 2 days in December. The records may have indicated it was activated once before at some earlier date. I can't recall off the top of my head now, but it doesn't give a record of full activation. The Commonwealth, as I recall, the Commonwealth asked for records of a PlayStation with this ID number for a certain block of dates. So, like, it didn't ask for records going back to whenever this PlayStation was first purchased. So it's got this information about the 2 dates it was activated in December.
Can I ask you a question? Oh, I'm sorry. Did you say?
Just to follow up, but the importance of it is that whether or not the PlayStation which Gessie had was the PlayStation that Souza had. That's the
Right.
core issue.
Right.
And so how does the Sony records bear on that?
Again, all the Sony records show is that it's the PlayStation that Jesse activated, so presumably it's the PlayStation that Mr. Barnett sold to him. But again, they don't say that this PlayStation that Barnett sold came from Christopher Souza. That link is missing. There's nothing saying a PlayStation with this ID number was owned by Christopher Souza at some point. That's not in the record. It doesn't exist.
Can I just ask a silly little question, which is if counsel had not, in your words, mishandled the DNA evidence, suppose it was all excluded, no DNA evidence at all, okay? What difference to the case?
Well, you say if the Commonwealth's results were not introduced.
That's right.
That's, well, the council got this DNA report, and the DNA report indicated that at least 6 of Mr. Barnett's alleles are not on those cords.
Right.
So my position is that, so the issue becomes under Wiggins, would the information he had cause a reasonable attorney to investigate further?
No, the question is, suppose he had been reasonable and he did everything you said he should have done, and got rid of the DNA evidence. Is that what you wanted as a result? No DNA evidence in at all?
No, I think,
Or the use of the DNA
I think he would get a
evidence?
DNA expert, find out Michael Barnett should have been excluded, and he would have wanted to present that at trial.
You want to
This
present
is
that at trial.
exculpatory evidence that a defense would want to present regardless of whether the Commonwealth presented its results. This is evidence that in a case you'd expect to find the DNA on the murder weapon, the perpetrator's DNA on the murder weapon. It's not there. The defense would want to present that in any case, regardless of whether the Commonwealth presented any DNA results.
You have a second argument, too, as I understand it, on the DNA, which is that, at least it was my experience, that jurors misunderstand what inconclusive means. They
Right.
think inconclusive means, oh, if they had enough, it would have been him, or maybe it would have been him. And we've said inconclusive means nothing, and don't talk about it if it's inconclusive, right?
Right.
And you're concerned that the inconclusive evidence coming in could have prejudiced your client.
Right. What happened here is that they have this report saying insufficient data. Their expert, Mr. Cunningham, testifies at trial, and he says, if he had said nothing more than there's insufficient data to draw any conclusions and left it at that,
Okay, on the investigation.
that'd be it. This is evidence with no probative value.
But didn't the expert
But he went beyond that.
Didn't the expert basically say, the expert testified the evidence did not afford an opportunity to make either an inclusion or exclusion, right?
But that's not all he said. He does say that, but then he goes on from there. That's, I believe, pages 78 and 79 of Volume 3. He goes on to say that these results are inconclusive because although there may be some matching alleles, there's also some missing alleles. And the Commonwealth introduces the chart showing where exactly the missing alleles and the matching alleles are. And he goes on to say it's inconclusive. Alleles could have dropped out because of the low level of DNA. And that's pretty much exactly what happened in the Cameron case. Same kind of.
Don't Cameron, they talk about that it may be masked, and there's, Cameron's a I mean, I understand this difference between non-exclusion and inconclusive is sort of an expert battle, but isn't there much more use of where it matches in Cameron than there is here? Significantly more.
I don't believe so. I think the testimony is very similar because in Cameron, the expert also testified these results are inconclusive, and then he goes on to say, but there are some matching alleles. And this court looked at that and said because he went beyond that, beyond just saying inconclusive, and he gave reasons why those alleles may have been missing.
Did the expert in this case go through and say it matches here, it matches there, it doesn't match here, but it may be masked? Does the expert do any of that here?
No, what he did do is say the reason it's inconclusive because although there are some matches, there's also some missing, and it could be because of the low level of DNA. And they introduced a chart showing exactly where those matching and missing ones are. So that's the testimony and the introduction of those charts that changes this from simply inconclusive to non-exclusion.
Is it brought up at all in closing? Is the DNA brought up in closing by the Commonwealth?
The Commonwealth says, again, it's pretty much similar to Cameron. The Commonwealth just says, we had DNA tests done. It was inconclusive. We can't tell you whether it's Michael Barnett. We can't tell you whether or not it's Michael Barnett. And they'll say, we can't tell you whether or not it's these other people they compared it to.
Yeah, but when it is allowed in, inconclusive is allowed in for Bowden, that's usually what we say, what the expert says. Doesn't tell you anything. So it wasn't misused in the closing. It just shouldn't have been a topic of conversation at all because you have the concern that the jury is going to think the alleles that drop out are not the defendant because there wasn't enough.
Right.
Yeah,
And-
but
and
I don't
again-
think the closing, I mean, going to Justice Kafka's question, I understand your concern from Cameron completely, but it doesn't seem like the closing exacerbated it.
No, the closing itself didn't, but again, the closing in Cameron was the same. That didn't exacerbate it either. It was strictly the expert's testimony. In Cameron also, the prosecutor simply argued, it's inconclusive. We can't tell you whether or not it's this person, exactly the same as in this case.
Isn't the PlayStation the DNA of this case, though? I mean, I understand that, actually, I don't understand the issue completely with the, with the Sony and, but here, the defendant is at the victim's residence, right?
Right.
And the defendant is selling stuff like PlayStation for drugs, right?
Right.
And the victim's PlayStation's missing. And this other guy who he's at his house, there's a PlayStation there. So, I mean, what are the chances that the defendant didn't take the PlayStation that's missing, even if it's not that particular PlayStation that day, and he just happens to die the same day? Do you understand what I'm saying about the PlayStation being like DNA? The chances of that PlayStation happens to be missing that night that he's there, and Susan ends up dead that day.
That's what the evidence is. Certainly, there's
Devastating
circumstantial evidence. I'm not disputing the
No,
Commonwealth has some.
I understand, I'm trying to understand how important, when the chief was asking about the Sony and the records, I understand that. I'm trying to get at how big a deal is it that the records don't tie this together, the Sony records. That's what I'm trying to get to.
Well, the only point I'm making is that the evidence in this case did not exclude the possibility that somebody else came in after Mr. Barnett and killed Christopher Susan. It was the actual perpetrator. And the DNA evidence is particularly significant because jurors do place great weight on DNA evidence, and a strangulation case is one where it's particularly likely you're going to find the DNA of the perpetrator on the weapon. And it's not there
I
in this
agree with
case.
that. I'm talking about the Sony separate and distinct from the DNA. I mean, I'm talking about just, it's an awful big coincidence. Mm-hmm. That's all.
If I can go back to the ligature, which I guess is the same thing as the cord, correct?
Right, right.
I've only looked quickly at Dr. or Mr. Lakin's report. But is it your view that a competent attorney would have called Dr. Lakin to the stand as part of the defense, and Dr. Lakin would have offered the opinion to a reasonable degree of professional certainty that not only that it could not have been the defendant's DNA on that
Yes.
ligature?
Yes, whether Dr. Lakin was the person they retained or some other DNA expert, yes, that testimony could have been obtained, and having been obtained, it absolutely should have been presented at trial. I think it's far more persuasive than anything else trial counsel was able to present at this trial. And again, it's evidence the defense would want to present regardless of whether the Commonwealth presented its own results.
So you're not really complaining, you are a little bit, but you're not really complaining about the admission of the testimony that they put in, because what you're really complaining about is that the attorney in this case did not offer his own evidence that says it could not have been the defendant. Because certainly if they had offered that evidence, you can't blame the Commonwealth for offering its expert to say it could have been him.
Right, but, well, it's three, yeah. So the first argument is obviously counsel should have retained his own DNA expert, got this evidence, and presented it. Not having done that, what he could have done and didn't do, given the information in the reports, he could have cross-examined Mr. Cunningham to elicit evidence about the missing alleles and the inconsistent nature of his reports. He could have used that as well to argue that Mr. Barnett should have been excluded. But if he's not even going to do that cross-examination to elicit exculpatory evidence, he should then have moved to exclude the Commonwealth's result, whether the view is non-exclusive or inconclusive.
But I mean, but pragmatically, the takeaway from their expert is we can't tell, but it could have been the defendant. And what you are saying is that you had the attorney had the opportunity to call his own expert, which said the takeaway from it is that, no, it could not have been
Right,
DNA.
right. And also the Commonwealth, having presented its expert, he could have cross-examined further to elicit some evidence there to suggest, this inconclusive result is wrong, he should have been excluded.
And did Lakin testify at the motion for new trial?
No, there was no hearing on this. The judge read it on the record.
So we
the
have to rely
affidavits.
upon his affidavit and his report.
Right.
And is his affidavit and report as strong? I looked at it quickly, the report, and is it as strong as what you described? That is, that he could have offered an opinion to a reasonable degree of professional certainty that it could not have been, that this
Yes.
the second set of DNA could not have been the defendant?
Yes, his report clearly states that Barnett is excluded as a contributor to the cords. He also analyzed the three reasons that the Commonwealth's expert give for saying why this is inconclusive, and explains why those are just incorrect. So it's very clearly laid out in his report why the Commonwealth's results are incorrect, why they didn't follow their own protocols in interpretation, and why Mr. Barnett should have been excluded as a contributor.
And does the record indicate that whether or not the person who was doing the DNA analysis knew that Barnett was the person who'd been arrested?
My understanding is the way the lab does that, they have separation between the analyst who looks at the known person's protocol, in this case, for example, the sample from Mr. Barnett, and a separate analyst gets the question samples and creates a profile from that. So they try and keep those things isolated.
Okay, but I mean, I see that you noted Dr. Dror. I know his focus is on the risk of bias.
Right.
Is there a risk of bias in this case?
Well, I think the risk of bias here is shown, for example, it's demonstrated in a couple of ways. One, as I mentioned in Ms. Walsh's affidavit, where she looks at different alleles with the microphones than she does for the chords, although they both qualify as what she calls smaller alleles. And so the ones she looks at for the chords are ones that miraculously Michael Barnett matches completely. On the ones she looked at for the microphones, though, he has missing alleles, but she ignores those when it comes to the chords. And then you go to the testimony at trial, which is that dropout could explain these missing alleles. And you look at the, if you look at the different people he analyzed, he'll look at very similar numbers of missing alleles with similar missing in similar places where they say they're small loci. And in some cases, it says inconclusive. Sometimes he says exclusion for no apparent reason for and they don't offer. There's no contemporaneous reason offered for why he found these. Said they might have been dropped out. And the lab protocols clearly state if there's only one missing without scientific explanation, exclusion. And they don't provide any scientific explanation at the time. Nevertheless, they say this thing's an exclusion. So I think there is good evidence of bias in both the original analysis by Mr. Cunningham and the affidavit by Ms. Walsh.
All right, thank you.
Thank you.
Ms. Spate. Good afternoon now.
Good afternoon. May it please the court, Hallie White, Spade, Assistant District Attorney for Middlesex on behalf of the Commonwealth. With me at council table is Assistant District Attorney Christopher M. Tarrant, who was the trial prosecutor. The question before the court, the primary question as regards the DNA evidence, is whether the motion judge who also presided at trial, heard the evidence, knew how it came in, knew what was emphasized, knew all the theories of the case, and knew where the evidence pointed, was within her discretion to decide that counsel was not ineffective for not having challenged the Commonwealth's DNA evidence. Now, I think we need to carefully separate here, and I see the panel tending in that direction, between the first argument that counsel should have put on his own expert to testify that the defendant was excluded as a source of DNA on the courts. Had he done so, it would not have rendered the Commonwealth's expert testimony inadmissible. Obviously, if it's relevant for the defendant, it's relevant for the Commonwealth to rebut it. So you would have had a battle of the experts, as in Millian and Epps. But the difference is, in Millian and Epps, the battle of the experts is about the very core factual issue of the case, which is whether the defendant's actions could have caused the child's injuries.
But what the defendant would say is that the expert, if it were an exclusion, is the very core of the case, because an exclusion means he didn't touch the PlayStation.
I disagree.
Yeah.
It doesn't mean he didn't touch it. And this is the sort of thing that would have come out had two experts testified. The defendant's own materials in support of his motion for a new trial talk about the phenomenon of secondary transfer. Mr. Shedd comes up here, puts his hand on the ledge here. I come up here, I put my hand on the ledge, I pick up his DNA, and then I go out and pick up a knife and stab someone, and Mr. Shedd's DNA is on the handle of the knife. Because I've picked up his DNA. The absence of the defense, and again, from a thin object, it's not a large flat surface. And it's also known, there's testimony about this, which I wish I had highlighted in my brief more, that the first responding police officer, the first thing he did when he walked into the apartment was to grab the cords and unwrap them from around the victim's neck. He said he wanted to see if the victim was still breathing, which is unfortunate.
What was the testimony as to the use of force that was necessary to strangulate the victim?
I don't recall specifically. I think it was
I assume
the
there had to
usual
be.
testimony in a ligature strangulation case, which is that a fair amount of force is needed over a given period of time. But again, if the defendant wipes down the cords, if he's wearing long sleeves that can cover his hands while he's doing the strangulation, there are explanations for the absence of the defendant's DNA. And had the defendant put in an expert, this could all have been explored.
Gloves would also do it, right?
Sorry?
Would gloves prevent it?
Would prevent the defendant's DNA from being deposited on the cords or any intervening substance. Would it be exculpatory? Yes, it would certainly have been favorable to the defendant. But again, this was the judge who presided at trial.
Yeah, but the judge's
Who saw the evidence.
The judge's argument to me is fundamentally flawed. I mean, for her, she's basically saying you didn't rely on the DNA evidence, and of course you could not rely upon the DNA
It was
evidence because it
inconclusive.
said not. But that's, to me, analogous to an eyewitness case in which an eyewitness says, I can't be sure that it was the defendant, and of course the Commonwealth can't rely upon that, when in fact that eyewitness arguably, or another eyewitness could have said, no, I saw the person and it's not the defendant. So the fact that it was not relied upon doesn't negate the fact that somebody saying, your witness said it could have been, and his witness would have said, no, it could not have been. So that's a big difference.
But the question again is not, the question is, was counsel ineffective for not having explored this further? And counsel's affidavit quite candidly says, I looked at this, I thought it was a really good result. You can't include my guy.
But it clearly is not as good a result
It's not
as
as good as an
saying
exclusion.
I can exclude my guy. It's
But
not only is it it could have been him, it could not have been him. I can say, members of the jury, if you credit the testimony of Mr. Lakin or the equivalent, it was not that the person who was strangling him over the course of how many minutes that it would take, who you would argue would have left some DNA evidence on that cord. The bottom line is, whoever that is, it's not Mr. Barnett.
Well, that makes a lot of assumptions, which is that there was no way that this person could have done the crime without leaving DNA on
I
the
understand
cord.
that, but the question is whether it's reasonable doubt. I mean, yes, there's no doubt the Commonwealth could
court
have
has-
said all that you say. He could have put on gloves, he could have tried to wipe it clean, then you'd deal with how successful it is to wipe off handler DNA. I understand that. But But we didn't have any of that, and that's the concern.
And where what we had was an inconclusive result to begin with. This court has never said.
From your
Yes.
expert, not from his.
Not from his.
His said, I
Not
don't,
not
I
from
can't
his.
tell you whose it is, but I can tell you who it's not.
This court has never said that counsel has to follow every lead down to its
Pretty
conclusion.
important lead as to whose DNA is on the ligature which was pulled. I mean, isn't that sort of the heart of the forensic piece of the case?
And but the forensic piece of the case was so small and so
It was
compared to
it was small
compared
because
to the
you
major
didn't have
issue.
it, but it would not have been small if the defense had it.
Although, if they put it in right, you would be saying their methodology is not, you'd have been, it would have been
Exactly.
a battle of the experts about whether
Exactly.
it really was an exclusion,
Which is
right?
what distinguishes this case, and this is extremely important because we keep citing Cameron and Cowles and Sullivan and Baker and all these cases where you post-conviction you do a new test that everybody agrees the defendant is excluded from. Okay, that's all those cases. In none of those cases, I think, was there any serious dispute as to what the new testing showed.
You still have
Okay.
Epsilon, where there was definitely a
It's
dispute
but
in
it's
the
a but
science.
it's a different that's a different kind of evidence with a different relevance
Okay,
to the
but-
case
but
I
the-
submit.
but in Epsilon-
And this court may disagree with that, but the
Well, I mean,
Cameron.
let's stop for a moment on Epsilon. Epsilon, Commonwealth puts an expert in which says cause of death was baby shaking or whatever the more modern term is. And there's no testimony from the other side that says this extraordinary event could have been caused by something other than that. Huge dispute in the scientific community. But we still said the jury's entitled to know that there's another side to it.
Yes, yes, and but that is, again, that's a highly controversial and opaque region of science that is very different from, you touch something, your DNA's on it, can we explain it if your DNA isn't on it? And I think that is a very different kind of evidence than what we would have had here, which is it him, is it not him? And we didn't even have, it's him, we don't know.
Can I ask you
Yes.
the same question in a different way as it goes to a substantial likelihood issue? So what we would have had with the expert is the defendant's expert would have said, you can exclude him. The Commonwealth would have had an expert that would have refuted that and said, number one, it doesn't, and number two, you don't necessarily have transferred DNA or gloves or whatever. There's just no way to know. And so that would have been the battle of the experts. And then you've got the PlayStation, and then you've got the defendant starts crying when he's talking to the police about the PlayStation. And so it's going to come down to, because I agree with what the chief is suggesting and disagree with your initial statement. It goes to the core issue, who did it? The question is whether the other evidence is enough in conjunction with the Commonwealth inevitable refutation of that expert that we have a substantial likelihood here.
I think that is the what that question boils down to. Was this likely? And again, it's not just we're putting in newly discovered evidence that is uncontroverted. It's we're adding a voice to the quarrel.
But he
And
doesn't
would
have-
that
But he
have?
doesn't have much to work with. This is probably the best thing he's got, isn't it? Look what we got on the appellate brief.
We've got little else.
This is the best thing
But
he's
that's
got,
not the
but he doesn't-
Commonwealth's fault.
Yeah, well,
I
which way
understand,
does that cut that they have little?
I think the fact that you have, and if we look at the entire case, the defendant admits to having been in the apartment, was playing video games, admits he was using the victim's phone to call his dealer 101 times in the course of 2 hours trying to buy drugs. The victim is strangled with a video game cord. 2 video game consoles are missing from the apartment. The defendant's girlfriend wakes up the next morning and sees a video game system in the apartment that was not there before. She leaves the apartment. She passes Amory Jesse, one of the defendant's dealers, in the hall. She comes back to the apartment a few hours later. That game console is gone. Amory Jesse buys a PlayStation 3, the same thing that is missing from the victim's apartment, from the defendant that day. It's missing a cord.
He also confesses, right?
And And the defendant
He confesses to Leal.
bizarrely bursts into tears when telling the police about something he thought about doing but didn't do.
Trying to sell the video game.
Bursts into tears a year and a half later and tells Manny Leal that he fucked up and he strangled Chris for a video game, and makes statements also in the jail calls to his girlfriend. And I know that this court has the exhibits. You can listen to the calls. They don't sound like an innocent person. And that was played for the jury, too.
So that's what I mean by the
It's an
video game.
extremely strong circumstantial case, and where this would have been disputed evidence, highly disputed methodology, this court cannot say it's likely to have influenced the jury's
Why
conclusion.
not? Why not? See, I'm a little bit, if it is then a battle of the experts, doesn't it become a more central feature of the trial?
It becomes slightly more central than when it's
Slightly more
not
so?
disputed, but weighed against this, all the other evidence.
I know, but doesn't he have to play the only card he has?
If he understood what he had. That was the problem. He didn't understand it.
Right, that's true, too.
It's,
I understand there may be overwhelming evidence. This was probably.
there is, and I think as circumstantial cases go, this is pretty close to overwhelming. I don't like to use that word,
But you are relying upon this informant's, the confession came from this informant whose credibility, no doubt, is being challenged.
and was challenged thoroughly at trial.
So it is after all.
But it's also
a
not,
ye-
that is also not the only.
It's a year and a half afterwards, and that's just to somebody who he doesn't know very well.
And it's also not the only. Well, he confesses because, and again, this is why it was
Of the
important to put
girlfriend
those
statements.
text messages in, because his girlfriend, who was just trying to provoke him, calls him a murderer and says you're going down in a text message, and he bursts into tears because he, in fact, is a murderer. If this court truly believes that putting on a defense expert to quarrel with the Commonwealth's expert creates a substantial likelihood of a miscarriage of justice such that it was an abuse of discretion for the trial judge to have said this would not have made a difference, then the remedy is to send it back for an evidentiary hearing to decide whether this expert's testimony would have been admissible and whether it's sufficiently scientifically reliable to have
So let
come
me
in.
ask you a question that I've never thought of until you just said that. Was this Judge Topman?
Justice Brieger.
Judge Brieger. When she's ruling on the motion for new trial, she's using a different standard than we are right now. She's not using substantial likelihood. So if we do what you just said, what standard does she apply in doing that?
I don't think she does apply a different standard because it's a motion for new trial before the direct appeal. And I believe, I would have to check her ruling, but I believe the standard she cites is substantial likelihood.
Right, but she's focusing on the fact that you didn't rely upon it. That's where she's coming from. And Mr. Shedd is saying that's not the issue. I know they couldn't rely upon it. The issue is the defense could have relied upon it, and it could have been the central piece of their argument. Your piece is it still would have failed. I understand that. But it's a different, it's a ship's passing in the night here a little bit. So.
No, it's not, because I think it's important to note that Justice Brieger's ruling assumes without deciding that the defendant's expert could have testified.
She does, right.
And so if this court finds that ruling to be an abuse of discretion, which the Commonwealth urges it not to do, she has to be given a chance to decide whether it would have been admissible, because she did not decide that question below. I submit that even to send it back for an evidentiary hearing means this court is substituting its view of the evidence for hers.
Wouldn't it? There's no question it would be admissible, given what you put in, wouldn't
No,
it?
it has to be scientifically reliable, and I refer this court to Commonwealth v. DeCicco for that proposition, which is that just because someone has letters after his name doesn't mean that he is providing scientifically reliable testimony.
He's not doing something, if we knew more about what he did, it would show that it's highly unusual, his methodology.
that his methodology is not generally accepted in the scientific community, which is what Sharon Hansen says in her affidavit, and what Justice Kottmeyer decided in Commonwealth v. DeCicco.
Where does this guy work? What is his?
He's in private industry, I believe.
And does he, in private industry, doing this kind of stuff, or is he just like a chemist or something?
I think he does DNA analysis. His CV is attached, and his affidavit spells out his current employment. But in DeCicco, you had a chemist from the Connecticut State Lab testifying that the defendant was excluded from the sperm sample in that case. And Justice Kottmeyer decided, after hearing testimony from both sides,
Sorry, which case?
DeCicco, Commonwealth v. DeCicco, I believe it's cited in my brief, that this evidence, that his methodology was not sound, it was not generally accepted in the scientific community, it was not scientifically reliable, and so it would not have been admissible. And she denied the defendant's motion for a new trial on that basis. And this court affirmed that ruling. So if this court believes that this would have been, if admissible, a real factor, then it has to send it back for an
Well,
evidentiary hearing for that decision to be made.
But your point is also that everything you just said goes to how much in this battle of the experts this expert would be challenged. At the same time, the PlayStation is like the functional equivalent of DNA in this case, or it's the most amazing coincidence of all time, especially taking into account that he starts crying about wanting to sell the PlayStation to the police. I mean, what are the
That's correct.
chances?
That's correct. It's a huge coincidence if not. And as for,
A lot of these cases which we're focused on, I mean, they're rape cases where, we know that this is critical evidence.
exactly,
Here-
DeCicco is a rape case,
I'm just
Cameron
trying-
is a rape case.
This thing, you have that second backup argument. Look, even if it's not him, he may have been wearing gloves. It's different from these other ones where we actually have, there's no doubt this is going to show that a rape occurred. Something-
Exactly,
Yeah.
or that the defendant is the rapist. And again, if we can, this is to jump a bit to the other argument that counsel should have not putting on his own expert, but should have tried to exclude the Commonwealth's DNA testimony. In Cameron, the testimony was very different. In Cameron, the expert holds up a chart and points to each allele and says, the defendant matches here, look at that, he matches there. Well, he doesn't match here, but sometimes the major profile masks it. He matches here.
Is there
He
some
doesn't-
of that here?
No, there is nothing of that here. And let me read the entirety of the testimony about the inconclusive evidence on the cords. The minor profile from the item itself, it's preceded by an analysis of the major profile, which is obviously the victim, the proper probabilities of a random match. The minor profile from the item itself, because of the drop, the number of places where there's potential dropout, the minor profile was inconclusive for comparison with the other individuals. And what does that mean? Does that mean you can't compare them? It means you can't draw a conclusion whether someone's actually included or excluded. The simplest way to say it is when you go to compare someone, there may be pieces of DNA that are similar to theirs, but at some locations, if there's DNA that doesn't happen to be the same as theirs, it could be because it dropped out. So we can't really draw a conclusion when DNA results approach these levels. Okay? Defendant is never mentioned by name. There's never any pointing to specific. It's entirely generalized. It's entirely abstract. It's very much like the testimony that this court
They don't put the
allowed.
defendants, they don't do any
The
comparison?
charts were there. The charts
The
went
defendants,
to the
with the-
jury, but there wasn't. I don't believe there was a sort of blow up that the
but there-
chemist is pointing to each allele one at a time.
But there is the jury is going to be able to do some of this, right? The defendants' alleles are there. I'm sure.
The jury, yes, the jury can do that, and the jury can look at the PlayStation records also. But the point is, it's not like the testimony in Cameron. And the testimony in Cameron itself, I just want to point out, this is dictum in Cameron. Because the real problem in Cameron was that they retested this sample 10 years after the conviction and found that it was female DNA, which is a problem in a rape case. So Cameron is not this case. And I also want to point out to the court that in what seems to be the leading case on this, which is Commonwealth v. Nesbitt, The chemist testified, and this is a case from 2008, that she was not able to exclude the defendant, period. And that was the testimony. I can't exclude him. And the court in Nesbitt found that that did not create a substantial likelihood of a miscarriage of justice. So it simply is not the case that every time evidence of inconclusive results comes in or can't include or exclude, it's actually non-exclusion and it can't come in. And as for the argument that it can only come in where there's a Bowden defense, this court has never said that, for one thing. Second, the reason why it was put in this case was the reason it's put in a Bowden defense, to show that the Commonwealth did a thorough investigation. And if this court wants to say it can't come in without a Bowden defense, that's grossly unfair, given that a defendant is never required to present notice of a Bowden defense, and in fact often only brings it up in closing.
But doesn't that speak, I mean, I take your point, but doesn't that speak to its importance? I mean, I understand that at a trial like this, if there had been no evidence of any attempt to ascertain the DNA on that ligature, given it, a jury, regardless of whether anybody argues it, would say, well, geez, how the hell can you conduct an investigation and not do a DNA test on the ligature that's used to kill the person? That's why I don't have a problem with your putting it in, but that also speaks to the perception of why it's central to the investigation of the case.
No, I disagree with that, because the case here, and I'll be quick because I'm over time. I know I was over time 3 minutes ago. This was a case where the Commonwealth, the law enforcement came to a dead end with this case. And nothing happened for over a year until suddenly we found out that Manny Leal was saying that the defendant had confessed to him. And the defendant's theory was that the Commonwealth wasn't working very hard to solve this case. And so the reason—
They don't ask for a Bowden instruction here, right?
No one asked for a Bowden. I don't think anyone asked for a Bowden instruction. And as we all know, there's no such thing as a Bowden instruction. And I'm sure many members of this panel have said many times, I'm not going to instruct on this, but you can argue it. But that's my point.
There is a Bowden instruction, but you're not entitled to it. But,
no one's. It's
but
never
the more
required.
important part is he didn't argue it in his closing, I gather.
And it often doesn't come up until closing. And so it's grossly unfair to condition admissibility of this evidence on something that
we do say
might only come up in closing.
We do say in
Largely,
in
but—
Commonwealth versus Fitzpatrick, right? Inconclusive DNA result admissibility, quote, turns largely on whether the defendant pursues a Bowden defense.
Again, largely, but that's not exclusively. And the reason we put it in, actually, was precisely because it didn't lead us anywhere, just to show that we did everything we could, but we didn't get anywhere.
So it's anticipatory Bowden defense.
In a sense, yes.
Well, no, but you're saying, I think, something different. You're sort of saying, wait a minute, what's the jury think we've been doing all this time? Well, we didn't have any conclusive DNA.
We didn't have DNA that led us anywhere.
So that's different than a Bowden defense. That's an explanation of inconclusive for a reason different than Bowden.
Yes, but the reason for putting it in is the same, which is to say that the Commonwealth did all that it could.
Mm-hmm.
Okay.
I would simply ask the court to affirm and not to exercise its extraordinary power to reduce the verdict.
Thank you.
All right.